All right, everyone, let's talk about the U.S. Supreme Court's decision in Crawford versus Washington. This is a 2004 decision written by Justice Antonin Scalia on the Confrontation Clause of the Sixth Amendment. This idea that criminal defendants have a constitutional right to cross-examine people who are being brought into court as witnesses to testify against them. So what happened in this case was you had the petitioner, Mr. Crawford, who was tried for both assault and attempted murder. The prosecution wanted to introduce a recorded statement that his wife, Sylvia, had made during a police interrogation, saying that the stabbing that he did was not done in self-defense. Sylvia, his wife, did not testify at trial due to the state of Washington's marital privilege. Crawford argued that introducing this testimony would violate his Sixth Amendment Confrontation Clause rights because he's not going to be able to cross-examine his wife. And so the trial court allows this testimony. Crawford gets convicted. The state Supreme Court affirms his conviction. So he's a convicted man. He's petitioning for a writ of certiorari to the U.S. Supreme Court. Justice Antonin Scalia writes the majority opinion, and they reverse. They say that this testimony being admitted does violate the Confrontation Clause. And so they look at the case that's on point, or the case that needs to be overruled here. That's Ohio versus Roberts. What Ohio versus Roberts held was that Confrontation Clause rights do not bar the admission of an unavailable witness's statement against a criminal defendant if that statement bears adequate indicia of reliability, which is a test met when the evidence either falls within a firmly rooted hearsay exception or bears particularized guarantees of trustworthiness. So yeah, the hearsay exceptions, you might be familiar with some of those. That's stuff like excited utterance, stuff like wills, those conveyances, stuff like present sense impressions. And yeah, this is not a good test in the eyes of Justice Scalia. He says that the Roberts test that was created is wrong because it admits core testimonial statements that the Confrontation Clause plainly meant to exclude. Testimonial hearsay statements may be admitted, but only if the declarant is unavailable and the defendant has had a prior opportunity to cross-examine that declarant. Admission of non-testimonial hearsay, of course, does not violate the Confrontation Clause. So it is the testimonial statements which we need to keep out. They, of course, need to be being used for the truth of the matter asserted. That's part of the definition of hearsay. So, for example, if you say, oh, if the statement is the car is blue, hearsay, it needs to be used to prove that the car is blue. That's the core component of hearsay. It can't be used for any other purpose like the effect on the listener. So that is the holding of Crawford versus Washington. Chief Justice Rehnquist writes a concurrence joined by Justice O'Connor where he disagrees with them, overruling Ohio versus Roberts, and says that Crawford can still win this case based on the Ohio versus Roberts standard. But yeah, it's a concurrence in the judgment. And so this is important because it's a shift. It overrules a case, and that's a big deal. It's a shift in favor of criminal defendants and a shift in favor of broad Sixth Amendment protections for criminal defendants, really trying to keep out those types of testimonial statements that are out of court, making sure that criminal defendants are going to get the opportunity to cross-examine people when people are not available and there are statements being used from them against them in court. Scalia was a guy who was pretty pro-criminal defendant on certain issues. This is one of them where he's really standing up for Sixth Amendment rights here. Yeah, it's an interesting case. You're going to read it in evidence class. I hope that you found this video useful. If you're taking an evidence law class, I hope that you can take it to the bank and get an A++ thanks to this video. Please like, comment, or subscribe to this channel. Thank you so much for watching. This has been The More the Merrier, and I look forward to speaking to you in my next video.